You've engineered a breakthrough in nuclear technology that could transform the world's energy landscape, and to protect the invention, you file a patent application. But the government doesn't just reject your invention, they effectively seize it and placing it under state control. Welcome to Section 4 of the Indian Patents Act, the legal mechanism where innovation collides with national security. Section 4 stands as a restrictive clause in the Indian patent law. It mandates an absolute prohibition on inventions related to atomic energy. Before the SHANTI Act amendment in December 2025 under Section 4, inventions relating to atomic energy could not be patented under any circumstances. If your invention fell within the scope of the Atomic Energy Act 1962, rejection was automatic. Once classified as an atomic energy invention, patent protection was impossible. In December 2025, Parliament passed the Sustainable Harnessing and Advancement of Nuclear Energy for Transforming, the SHANTI Act, which fundamentally reshaped the legal treatment of nuclear innovations. The amended Section 4 now permits patents for inventions relating to nuclear energy, subject to two key conditions: compliance with the Patents Act 1970 and Section 38 of the SHANTI Act.
This amendment didn't eliminate the bar, it simply redrew it. In practice, Section 4 remains a conditional bar. It's no longer an absolute wall, but the gate is extremely narrow.
The question is, why does the government maintain such fierce control over nuclear technology? The answer lies in the shift from commercial incentive to state-mandated secrecy. In standard patent law, public disclosure is the core principle. You trade your invention's secrecy for legal protection. The public learns how your innovation works, and society benefits from technological advancement. The patent controller's job is to balance individual rights with public interest. But nuclear technology operates under a completely different legal regime.
Nuclear technology is not a private commodity. It is a strategic asset that belongs exclusively to the state. Public disclosure of nuclear innovation is viewed not as progress, but as a systemic risk, a risk to national security, to non-proliferation commitments, and to India's geopolitical standing. This principle hasn't changed even after the SHANTI Act. What has changed is the mechanism. Instead of an outright ban, the law now allows selective patenting under government surveillance.
The Patents Act doesn't provide a comprehensive definition of what constitutes an atomic energy invention. Instead, it defers to the Atomic Energy Act. Any invention that falls within the definition of atomic energy under the Atomic Energy Act is automatically excluded from patentability, or post-SHANTI, subject to Section 38 restrictions. Under the amended Section 4, an invention relating to nuclear energy may be patentable if it complies with the general criteria of the Patents Act: novelty, non-obviousness, and industrial applicability. And 2, it does not fall within the reserved categories specified in Section 38 of the SHANTI Act, or it is deemed eligible for patent protection despite falling within a reserved category, subject to conditions imposed by the government. If you're preparing for the patent agent exam, understanding Section 4 is essential. If you found this breakdown valuable, subscribe to The Patent Scientist for more deep dives into India's toughest patent law provisions. Thanks for watching.